All right, here's my biggest beef. This new right of rescission in any part of the claim is denied. Think how this plays out. You've either got a repair versus replace dispute or, any kind of simple supplement. The contractor calls the adjuster, tries to get the supplement approved. The adjuster says no. As soon as he hangs up with the contractor, the adjuster then calls your homeowner and says, your contractor is being greedy and unreasonable. And I'm allowed to advise you that you now have the legal right to cancel the contract with him without any penalty or obligation. And you know what? I've got just the guy who is happy to do that scope of repair for my pricing. It'll allow them to funnel a ton of work to preferred vendors. Comes along with 13 additional roofing related issues here. The first few deal with paying for leads, rebates, eating deductibles, kickbacks, etc. Here in 3, you're not allowed to collect more than 50% up front as a deposit. So simply getting an ACV check signed over that's for more than 50% of the contract amount could get you hammered with a consumer protection lawsuit. The bill is obviously intended to benefit insurers and drive a wedge between the roofer and their customer. This bill would benefit attorneys and public adjusters because the contractor would be silenced and feel like they're walking on eggshells. So we would get a lot more business. This bill, if it passed, it would really benefit me because hundreds of contractors would be calling me to make contract revisions. Frankly, I think one of the biggest beneficiaries would be estimators. If you need an estimate, a formal estimate that you're gonna take to the bank on every single job right up front, I don't know that there are enough estimators in Ohio to handle that workload. So from a roofing standpoint, some of the bigger companies have relationships with property management companies, and then the property managers will kind of make intros to condo boards and feed them the business. Some roofers can get around the property management company barrier and those existing relationships just by going straight to the board. So just keep in mind with these though, fewer and fewer insurers are actually offering condo coverage because of everything I just said. These are amazing claims. They're great claims to work if you're on my side of the aisle, so everybody wants them. So I've handled dozens and dozens of these over the years, and there are some pretty common things I run into. First is probably late notice. So a storm occurs weeks or months before you're even out there initially. And you have to go back and forth and finally get permission to do the actual inspection from the board. Then you have to wait on the board to actually decide whether or not they're even going to file a claim. Sometimes they'll even want to consult their association attorney if you're going to ask them to sign anything. You know what attorneys do. They really slow things down. Months can go by when dealing with boards because they don't get paid. They meet monthly or some quarterly or some yearly. So things take time. Now, before you know it, it's been 6 months since the storm before the claim even gets on file. And then the insurer's approaching it, a red flag from the very beginning. Now, if an insurance company is prejudiced by late notice, they can try to argue that they don't owe a penny, even if the claim is otherwise legitimate. So it's something to be cognizant of and, keep the ball rolling. Let your client know that that's something that they have to keep in mind as slow as they may move. So when I'm able to put up hail hit after hail hit after hail hit photographs, and they've got their high-paid engineer testifying that there's nothing there, people like you and me are typically going to say, if it walks like a duck and talks like a duck, it's probably a duck, right? That's what the jury found. All right, guys, I think it's quitting and drinking time. Thank you for your patience.